Welcome to the DC Bar Community's Law Student Podcast with your hosts, Sienna Heard, 3L at American University, Washington College of Law.
Elena Hoffman, 3L at the George Washington University Law School.
And Delali Dagadu, 4L at UDC David Ed Clark School of Law. You're listening to Let's Brief It.
Hello and welcome to Let's Brief It. I'm your host, Sienna Heard. Today's topic, employment and labor law, impacts virtually everyone. Between discrimination policies, hour and wage laws, wrongful termination, unions, and collective bargaining. If you have a job, employment and labor law has an impact on your life. And in today's world where the COVID vaccine is a big topic of discussion, employers have been dealing with new legal questions about vaccine policies in particular. So I'm very pleased to introduce today's guest, Mike Volpe. Mike is a partner at Venable LLP in the New York office, who serves as the co-chair of the firm's labor and employment practice group. So Mike, I would be pleased if you would speak up and introduce yourself a little bit and maybe talk about your career history and how you got to the place where you are now.
Sure. Well, it's a pleasure to be here. My name is Michael Volpe, and I am at Venable, as was mentioned. I've been a labor and employment lawyer for about 30 years. Prior to that, I was a stagehand in the theatrical business in New York City while working through college, graduate school, and law school. And I always thought that I was going to be involved in labor relations in some way, one side or the other, that is union or management, because of the background I had in working in an industry that was highly unionized. I was fascinated by dealing with people and talking to people every day and helping them work through problems. And lo and behold, 30 some odd years later, here we are. So our group at Venable is 50 strong across the country, working on day-to-day issues that affect employers in the unionized or non-unionized context. And it's exciting. And the last 18 months or so since the pandemic started, it's been challenging, but some really interesting questions have come up.
Yeah, definitely. So I'm wondering, what does labor and employment practice look like on a regular basis at Venable? I know I've talked to a handful of labor and employment lawyers at the firm, and they've told me a little bit about litigation versus counseling employers. So I'm wondering about that and what type of legal questions are common, like you were just alluding to.
So the day-to-day practitioner deals with clients on a regular basis, and usually a number of clients each day, which distinguishes what we call L&E lawyers, labor and employment, from other lawyers. We don't just work on one matter, one will, one tax issue, one commercial litigation, one intellectual property matter. We work with 5 or 6 clients a day, sometimes 10 or more, and we try to help them solve problems each and every day. In addition, if you're not giving advice and counsel, you're litigating claims in federal agencies, state courts, federal courts, or other forums like arbitration forums involving in the unionized sector. And quite frankly, it's fast moving. It's not for the faint of heart or the weak of stomach, and it presents difficulties, but is very exciting because you're dealing with day-to-day problems affecting employees and employers, and it's very rewarding.
Yeah, I could definitely see how that would be rewarding. I'm wondering if you can also tell us a little bit about the distinction between labor and employment. I know some of our listeners might not be familiar with the distinction.
Sure. Well, the employment law side deals with every topic you can imagine that affects the daily terms and conditions of employment of employees for employers. So whether it's an individual who is an administrative employee or a senior executive or a new employee fresh out of college or law school, everyone has different local, state, and federal laws that apply to that employee that have to be complied with. And what I'm referring to are the anti-discrimination statutes, the Family and Medical Leave Acts, the wage and hour laws. And we give advice and counsel on each and every of those topics and others each day to employers so they're in compliance with the law. On the labor relations side, somewhere around 15% of the workforce in the United States over the last 30 years has been unionized, and we do advice and counsel and litigate and represent the interests of employers in terms of either being unionized or being subject to what's called a union organizing campaign. And it takes on many different legal issues and concerns. and it's very technical. There's a federal statute, the National Labor Relations Act, and then there are local laws that apply to unionization. And we help clients through the myriad of laws on that side of the practice, if you will. When a client has had a union for a number of years, most disputes are resolved through grievance and arbitration processes that are outlined in what's called a collective bargaining agreement that the employer and the union negotiate. And we are expert in dealing with those contracts and negotiating those contracts and helping clients through the various issues they see each and every day. So I've said a lot on that, but it's a very complicated area that we find to be exciting and fast moving and, again, very rewarding.
Yeah, thank you for that explanation. So one thing that I've been thinking about lately, and that I've talked to with some of the labor and employment lawyers at Venable in recent months, is the fact that this current climate that we're in, with COVID being such a concern, even still today, and with now, of course, we know that we have vaccines available, but it sounds like employers are facing some really challenging questions right now about vaccines, what their policy should say in terms of what exemptions are allowed, and as well as, some of these case-by-case basis cases that come up with employees a lot of times being resistant to vaccines. So I understand that the two exemption categories are medical and sincerely held religious beliefs. Is that correct?
Basically, yes. And what's interesting is, to your sort of line or topic of questions here, the federal government, President Biden, recently came out with a statement that there would be a vaccine mandate for employers who had 100 or more employees across the country, even private sector. There's been a lot of pushback in many states with regard to that. The new OSHA regulations that would enforce that directive just recently came out, and they're going to be debated and litigated. But then you have each state coming up with its own rules that apply to different industries as to whether or not vaccines are required, for example, to go to a restaurant or go to a theater or go to a show or go to a sporting event. And what we do each day is we advise clients on those issues and on the issues that you've raised, whether or not an employee or an individual has an exemption from a vaccine mandate based on a medical reason or a sincerely held religious belief. And as we speak today on this podcast, that issue is being litigated. For example, in New York, in the United States Court of Appeals, there'll be arguments soon on whether or not a religious exemption should be recognized to a vaccine mandate. And it's a very interesting issue. So you're correct that those are the two exemptions that exist currently, and there's some debate as to whether or not that matter will get to the Supreme Court. I believe it will, but we'll see in the coming weeks.
Yeah, that is definitely interesting. And I also wanted to touch on that note that you raised about the OSHA regulation from President Joe Biden that is a point of contention for a lot of people currently. I was able to look at a source from Law 360 that talked about this recently. And I actually have a quote from that says, "The Occupational Safety and Health Act requires OSHA to issue an ETS if the agency determines that the employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards." So it sounds like employers that are challenging this new rule, or that will come from a result of Biden's mandate, would have to show that COVID-19 doesn't rise to a grave danger at this time, and that a vaccine or weekly testing mandate isn't necessary to protect the workers. So this is definitely interesting, and as you pointed out, is still developing. So it will be interesting to watch as more developments arise.
Yeah, I think what's going to be interesting is how when the final rules and regulations come out from OSHA and the federal government, how employers will challenge, or the Chamber of Commerce or a state Chamber of Commerce will challenge the federal regulations. So, for example, there could be a challenge just under federal law, meaning challenge to the administrative mechanism by which the president issued a directive, and then OSHA, the agency charged with enforcement, came out with its rules. That challenge could exist. It could be a challenge based on whether or not companies are actually involved in interstate commerce. If you're not involved in interstate commerce, there's a basic premise of law that you shouldn't have the federal laws applied to you. So then we get to all the as you've raised, the sort of potential medical issues or the potential religious issues. And there could be a variety of reasons that the eventual federal mandate and regulatory framework is challenged. And in the weeks to come, it'll be very interesting for employers across the country of all sizes. Because after all, even if you have 80 employees and are not covered by the federal law as currently constructed, you may, from a recruitment perspective, meaning from the ability to keep employees, determine that you need to have a vaccine mandate or not, depending on where you are in the country. So it raises lots of issues for clients and employers across the country.
Right. Yeah, that makes sense. Absolutely. So now pivoting a little bit away from COVID, although maybe your answer will be related to that. I'm wondering, have you noticed any particular shifts in the overall landscape of labor and employment law since you've been working in the field? So maybe this could be types of questions that have become more common or shifts in jurisprudence.
Well, the shifts in jurisprudence, we deal with federal and state and local laws. So in the states and localities, if you have, let's call it more liberal or more democratic policies and procedures, the application of law and the policies and procedures that an employer would have to follow can differ. So we have to be quite nimble in our practice and stay abreast of all developments so that we can advise clients on a daily, weekly, monthly, and annual basis as to changes in the law. What I've seen over time is that the laws in the United States have not provided, for example, family and medical leave in a manner similar to other industrialized nations, democracies in the world. And there's been a push to try to bring us up to a level that we might see in other countries. And that's important. I think personally it's warranted, but it's a struggle for some employers who didn't put that into their business model and can't afford it. So those are the kinds of things we've seen change over time. We've seen recently with the Me Too movement and a new focus on inappropriate workplace behavior, some changes in laws and changes in the standards that apply to the application of those laws, so that someone who says that there was inappropriate workplace behavior can bring a claim against their employer if their employer did nothing and had knowledge of such behavior. We've seen a change in those standards to give rise to more claims, and we see some of that. And in direct response to your question with that background, I would tell you that one of the biggest changes we've seen over time is an increased need for our clients to hire lawyers and help them through the process of investigating inappropriate behavior and potentially unlawful behavior claims that emanate from workplace interactions, employee to employee, employee to supervisor, et cetera. So that's been interesting, exciting, challenging, and quite frankly, fun. Keeps the job fresh and new.
Yeah, that definitely does sound interesting. And I'm glad to hear about those expansions for, providing for ways to address inappropriate workplace behavior, because that's certainly important. I'm wondering, what are some common misconceptions that you've seen about labor and employment law? Are there particular things that people don't seem to understand about the field of law?
Well, I think that in our practice area, one of the misconceptions is that we, labor and employment practitioners, can just jump on a phone call and be knowledgeable of every local, state, and federal ordinance that it could apply to a scenario. And that's just not fair. When you have cities, municipalities, state governments, and the federal government all passing laws that affect the same topics, family and medical leave, paid sick time, requirements for PTO or paid time off, et cetera, it is incumbent on a practitioner to explain to clients, I can get back to you on this question quickly, but it's going to take a little bit of time. So one common misperception is that we can just rattle this off the top of our head and have the database of all 50 states, the federal government, and the thousands of local and municipal governments in our head. And that's just not true. It requires much more thought and processing to give a client the correct advice. The other thing I would say is that the practice of labor and employment law, as I said earlier, is just not like other areas. You have to have the ability and want to have the ability to juggle a variety of clients and topics on a day-to-day, week-to-week, and month-to-month basis. You don't typically work on one big project for months at a time. Some of us find that exciting and challenging and welcome it, and some don't. But I think it's a great way to practice law.
Well, that second answer actually provides a great pivot to my next question, which is, what are some of the things in this area that you have found most challenging and most rewarding about this practice area?
Most rewarding, I would say, is you interact with people on a day-to-day basis while you have to read a statute and read a regulation and read a Supreme Court decision and then take the underlying legal principles and rules that flow from that and apply it to the facts that are presented by your client in the situation involving an employee or a group of employees, and then help the client make a business decision on what's right to do. I think that's very rewarding because you impact the ability of the client to effectively manage his or her business or their business. And at the same time, you obviously try to comply and do comply with the law in terms of affecting the lives of individuals who work for employers. So it's very rewarding to know that you're actually making a difference and you can help clients mold policies and craft policies and implement policies that allow them to successfully operate under the laws and have a successful business. I'd say the most challenging thing is the speed with which clients need answers to these questions. They typically call you when the problem is, the fire has been lit and the problem has come about, and they want an answer right away. Pretty challenging, but we obviously work through it as best we can.
Yeah, definitely. That also, I think, ties back to the point you made not too long ago about, clients expecting you to have the answer right off the top of your head. And I think that part of that comes from people's misunderstandings about what law school is, right? So many people expect that once you get out of law school, you just know all of the laws. And I think that's sort of a disconnect between what people understand law school to be and what it actually is.
All law school does is give you the foundational basis to practice law. The practice of law is a journey. It's a marathon and not a sprint. And it requires the constant updating of your knowledge base and the application of your knowledge base to a client's problem to help a client through the problem in making certain that they've done the best thing that they can do to operate effectively and efficiently in our society.
Absolutely. I think that's a great way of putting it. And if only our clients and loved ones understood that a little bit better. But yeah, we take it with grace. So I have one final question for you. And because we have a lot of law student listeners, I'm wondering what advice you would give to law students interested in getting into the labor and employment law world.
Well, first and foremost, any law student should consider the following in terms of A, work environment that they'll be in the future, and B, the area of law they're practicing. There's two things that are critical. A, make sure the people you work with, you like, you trust, and you think you learn from. In other words, sometimes you're right, sometimes you're wrong. You learn from them. They're good mentors. They give you constructive criticism and feedback where necessary, and they support your career as much as they can. So you need to be in a work environment that you like. And B, you need to do work that you like. Too many lawyers find themselves 20, 25 years out of law school where they just don't enjoy the content or the subject area. It could be tax, it could be IP, as we mentioned before, it could be bankruptcy, but find something that you really like. I happen to think that for all the reasons we've stated during this discussion, the practice of labor and employment law is exciting, ever-changing. Who anticipated the Me Too movement, 30 years ago? Some people probably did and called for it, but I don't think the speed with which things transpired over the last couple of years was anticipated by many, and the changes that have come about and need to continue to come about were not anticipated. So labor and employment law gives you a unique opportunity to work on a variety of issues that affect everyday life and families and relationships, and at the same time help guide clients through the chosen business area that they're in a successful way.
Well, thank you so much, Mike, for those kind and inspiring words. And I'd also like to thank you for being a guest on this podcast. It's been a pleasure. I've loved speaking with you.
Thank you. Thanks for your time today.
And to our listeners, thank you for joining us in this deep dive into labor and employment law, especially given the current complexities raised by COVID-19 vaccines. I've certainly learned a lot from our guest, Mike, here, and I hope that you have too. So until next time on Let's Brief It.
The DC Bar law student community strives to engage and support law students before you graduate and expose you to the tangible benefits of joining the DC Bar and DC Bar communities. Curated programming allows law students to participate in substantive content programming, leadership trainings, networking with practicing attorneys in fields of interest, writing opportunities, and other activities designed to expand your legal education beyond the classroom. Make an investment in your legal career by joining the law student community. To learn more, visit us at www.dcbar.org or email communities@dcbar.org. We look forward to hearing from you.